finally in this section, the union's holy grail, official and protected industrial action, which enables the unions to strike without fear or repercussions to themselves or their members. In the event of official industrial action, dismissal for taking part in protected action will be automatically unfair where the dismissal was within a 12-week period beginning on the day the employee took part in the dispute. That much is straightforward. In relation to the second point on the slide, this can be more tricky, and many factors have to be looked at. The impacts on other areas are listed at the bottom of the slide. Non-payment of wages. Continuity of employment is not broken, but the time does not count towards a calculation of continuous employment. An employer can redeploy existing labour to assist in a strike, but they are prevented from taking on agency staff. They can employ temporary workers directly without using an agency, and they can use agency workers after the strike to deal with a backlog. I'd like now to turn to the dispute between British Airways and Unite the Union, which has been ongoing for the last 6 to 8 months. If we look at round one, as I would refer to it first of all, around November 2009, British Airways was proposing to cut cabin crew on long-haul flights from 15 to 14. They also announced a 2-year pay freeze with effect from 2010. New contracts were also proposed for fresh recruits and newly promoted staff. 92.4% of British Airways staff voted in favour of strike action. Unite gave British Airways notice of a 12-day strike by cabin crew over Christmas 2009. BA applied for an injunction to restrain Unite from proceeding on the 17th of December 2009. The key issue before the courts was, should employees who have accepted voluntary severance be entitled to vote in the ballot? British Airways argued they should not have been, and that this invalidated the ballot. The law on this is reasonably complicated. The information or lists that the union provides the employer must be as accurate as is reasonably practicable. Entitlement to vote in the ballot must be accorded equally to all the members of the trade union whom it is reasonable at the time of the ballot for the union to believe will be induced to take part, or, as the case may be, to continue to take part in the industrial action in question, and to no others. Unite argued that any breach of this ballot requirement was accidental, and that any failure to comply was on a scale which was unlikely to affect the result of the ballot, and should therefore be disregarded. Unite's case on paper was seemingly strong. They had 3 statutory defences to the claims against them. But in the High Court, they disagreed with Unite. They did not believe Unite's evidence. According to the court, it would have been reasonable and practicable for the union to ask its members whether they were leaving in November and December 2009. It would also have been a practicable and reasonable step to inform the members that if they were leaving, they were not entitled to vote in the ballot. The court also said that a strike taking place over the Christmas period was a fundamentally more damaging action to the employer and to the wider public than a strike taking place at almost any other time of the year. The balance of convenience therefore favoured granting the injunction, and the employer was entitled to the injunction sought. Then in February 2010 we had round 2 of the dispute. The same issues were at stake, plus into the mix British Airways had added cutting travel concessions for cabin crew. A ballot was held, and the result of the ballot fairly communicated to British Airways. 9,282 votes had been cast, 7,482 were in favour of industrial action, 1,781 were against, and there were 11 spoiled ballot papers. Now, the law required Unite to advise BA, in order to retain their statutory immunity, of the numbers of votes cast, the individuals answering yes, the individuals answering no, and the number of spoilt balloting papers. British Airways then applied to an injunction to the High Court on the 17th of May because they had not been advised of the number of spoilt balloting papers. So what had they done? They had provided copies of the independent scrutineer's report. Copies of the report had been made available. News sheets containing the statutory information were made available. The statutory information was put on Unite's websites. A text message announcing the result was sent to members. A press release giving the result, but not all of the statutory information, was put on the union's websites and emailed to members. And a video of the Assistant General Secretary announcing the result, but not all of the statutory information, at a press conference was put on the website. The High Court held that Unite had not complied with all of the statutory requirements. But on the 20th of May, the Court of Appeal allowed Unite's appeal. The gist of the decision was that Unite had communicated the information and that using modern communications to do so was sensible. Crucially, it was unreasonable to require Unite to prove that every eligible member had personally been sent his or her own individual information as to the ballot result. So, one or two reflections on the British Airways case. Was or is it worth it? The costs to BA are rumoured to be around £100 million, and ultimately the strikes have gone ahead anyway. We've had 22 days of strike already this year. British Airways have vowed to continue with legal proceedings to have the strikes declared unlawful. Bear in mind the actions we're talking about are interim, injunction or interdict applications. They haven't involved full trials on the facts. Even if they proceed and British Airways win, the maximum they can recover in damages would be £250,000. According to the press reports, Unite has reached an agreement in principle with British Airways on the key changes. But in the meantime, the dispute has generated its own sources of conflict. When cabin crew last went on strike in March, the airline said that staff who took part in that strike would lose their travel perks permanently, including no longer being allowed to buy heavily discounted tickets. The union wants those perks restored. Was there a winner here? What about PR? What about costs, impact on staff morale? It's a sign of the relationship breakdown between Unite and British Airways. Unite allege they must fight on to stand up to British Airways' bullying tactics. But BA are now in a position where there's a pride or a principle issue. As the Lord Chief Justice said in the Court of Appeal, the parties should never have let this dispute come before the court. The court recommended that mediation be used. It must be resolved by negotiation. Legal processes do not constitute mediation. To the contrary, they often serve to inflame rather than mollify the feelings of those involved. Just briefly, I'd like to mention some common queries which arise from the employer in regard to industrial action and balloting. First of all, what's the position with non-union members? Can they strike? The law makes no distinction between union members and non-union members in terms of the employment protection it gives to employees participating in a strike or other industrial action. To do so would arguably infringe the right to freedom of association under Article 11 of the European Convention on Human Rights. Where a union has called a strike, following a successful ballot of its members, any protection from dismissal extends not only to members of the union, but to all employees who participate. However, a strike in which none of the participants are union members cannot be protected, although it will always be treated as if it were official. Therefore, from the employee's point of view, it will be treated as if it had been called by a trade union, but without a ballot. Is it legitimate for employees to join the union a few days before the strike? Are they protected as well? The answer to that is yes. And what happens when there is more than one union recognised? Do they have to do separate ballots and different timescales? Where there is more than one union balloting members employed by the same company in respect of the same dispute, the Code of Practice provides that arrangements for the different ballots should be coordinated in order that the ballots are held on the same day and the results announced at the same time. What are the timescales for calling a strike? Unions must send the employer the following: notice of intention to ballot at least 7 days before the ballot, a copy of the ballot paper at least 3 days before the ballot, although they are usually sent at the same time, notification of the result of the ballot as soon as reasonably practicable, notice of industrial action at least 7 days before the action is due to start. They must also, as soon as practicable, take reasonable steps to inform any employees who are entitled to vote of the result of the ballot. That's the point we've just looked at in the BA strike. The information must include the number of votes cast, the number for and against, and any spoiled papers, although it need not be in writing. How far can a union go to increase membership prior to a strike? Are there any boundaries in law to actively seeking new membership? The answer to that is no. There are no boundaries. And finally, could the union bring Britain to a standstill? This is the question I proposed at the start of my talk. Bob Crow has suggested a series of coordinated strikes on the same day. This would involve multiple unions, multiple workplaces, many industries, potentially hundreds of thousands of employees. This kind of action could cripple the country. So can the unions do it? Well, the answer is potentially yes. However, as I've already explored, each union must have a genuine dispute with each employer and in some instances at each workplace. If not, the action cannot be secondary action and therefore would be unofficial and unprotected. The balloting requirements must be followed. Surely some unions will make mistakes. But the big question for me is, would employees across the country really support this? I have to offer my own view that I think and hope that more employees would refuse to strike than those who would. But of course this depends very much on the nature of the government's austerity cuts and the resulting spin that both the unions and the government managed to put on it. Another interesting point to leave you with is if all employers challenge the ballots on the same day, whose prices cope with the influx of applications for injunction or interdict. This, of course, would be on the basis that the court service had not already gone on strike. Thank you very much for your time. Attached to the end of the slides is a section on balloting, which I'll leave you to look at your leisure with some notes. This is a technical part of the law relating to industrial action and is probably better read as and when you need it for the guidance contained in the slides. Thank you.